everyone, and thank you so much for joining us for today's presentation about the E-1 treaty visa. My name is Dustin Saldarriaga, and I'm a senior associate with Scott Legal PC. Our founder of our firm, Ian Scott, will be on this presentation as well. We're very fortunate that he'll be sharing his experience with the E-1 visa. Ian will be presenting the second half of this presentation, and I will be presenting the first half. Before we get started, a few procedural items. The first is that although our firm does have a focus on business immigration, we actually handle the full spectrum of U.S. immigration law, and that includes temporary visas such as the E-1, the E-2, student visas, temporary work visas such as the TN, visitor visas, but we also handle green cards, permanent residence, and immigrant visas, such as employment-based green cards, family-based green cards, etc. So we hope that if you have any questions or any needs involving U.S. immigration law, that you won't hesitate to reach out to us. One thing that I think helps our firm really stand out from other immigration firms is that our founder, Ian, has actually personally navigated the process himself on a number of visa types, including a treaty visa, the E-2 investor visa. Our firm was actually founded on an E-2 visa, and the fact that Ian has personally navigated the process really informs how we work with our clients. Before we get started, I did want to share that we try to do at least 2 of these webinars a week at this point. So those run the full spectrum of topics within U.S. immigration. So we do hope that you'll sign up for future webinars. After this presentation, we'll send you an email where you can sign up for those other webinars. We'll also send you in that email a link where you can schedule a consultation. Consultations are wonderful because you can share with us the specific circumstances of what your goals are, what your any complicating factors that may be present, and we're happy to talk with you about that and make recommendations that are unique to your scenario. So don't hesitate to schedule a consultation. We probably won't get into those discussions during a webinar, since a webinar is not the best forum for that, but schedule a consultation and we would be more than happy to talk with you about that. We will also send you a copy of this PowerPoint presentation after the presentation, as well as a guide that really does a great job of summarizing the best information that we have on the treaty visas, the E-2 and E-1 treaty visas. If you have a question during this presentation, please do share it with us through either the chat function on Zoom or the Q&A function. I have both open on my screen and we'll be monitoring those. We'll probably save questions for the end of the presentation, but we do plan to get through all questions that come up, so don't hesitate to send those in. All right, without further ado, let's go ahead and get started discussing the E-1 treaty visa requirements. So I've used the expression treaty visa a few times. So what does that mean? If you see this bullet on your screen that says the first requirement is that you must be a national of a treaty country. So the E-1 visa is unique along with the E-2. The E-2 and E-1 visas are unique in that they are established through treaties between the United States and a number of foreign countries. So there are at this point, I believe, over 80 treaty countries. So these are countries that have signed treaties with the United States that allow visas for people who want to come to the United States to essentially engage in international trade. And we'll talk about how that trade qualifies for an E-1 visa in more detail in a later slide. But for now, what is important to know is that there must be trade specifically between the treaty country and the United States. And any applicant for an E-1 visa actually needs to hold a passport from that treaty country. And I'll refer to those countries as treaty countries. Again, there are over 80 treaty countries, and they really do span the globe. There are treaty countries in Europe, in South America, North America, Canada, Mexico, Asia, They do change occasionally. So what you can do if you're curious, if you're not sure if you have treaty country nationality, is to Google U.S. Department of State E-1 treaty countries, or even just E-1 treaty countries, and you'll see a list of countries that have those treaties with the United States. Now, importantly, to be a national of a treaty country, you only need to hold a passport from that country. You do not need to have been born in that country. So as an example, if you were born in India and naturalized, became a citizen of Canada, so now you have a passport from Canada, you qualify as an E-1 national because Canada has an E-1 treaty with the United States and you hold a passport from Canada. So the other thing I'll quickly say about nationality is it's fine if you are a dual national or have nationality from more than one country, as long as, again, if you have that passport from an E-1 treaty country, you meet that nationality requirement. So the next requirement is that there must be trade. And I mentioned before that what is relevant is trade between the treaty country and the United States. So there must actually be an exchange of qualifying commodities. We'll talk about later that these can be goods, these can be physical, tangible items, or these can be services that are being traded between the United States and the treaty country. That exchange needs to be traceable and identifiable. There needs to be documentation that proves that trade is occurring. And in general, the trade needs to already be in existence. So it's important that you be able to show that the business is already engaging in trade between the treaty country and the United States. Next, trade must be substantial. This is a somewhat vague term, substantial. What is substantial trade? We'll talk a little more about what that means later. The trade, as I mentioned, must be international, so it must be between the United States and the treaty country. Next, the applicant, the E-1 trader, must be coming to the U.S. to engage in that trade. So when a person is successful and receives an E-1 visa, they receive work authorization that is limited to engaging in this trade. And that is really critical. If you're coming to the U.S. on an E-1 visa, you cannot start a side gig, say driving for Uber, or you need to be very careful starting a new LLC or a new corporation and engaging in a new business. You need to be coming to the U.S. in order to facilitate this trade. And finally, you need to have the intent to return to your home country at the end of your visa. Another way to say this is that an E-1 visa is a non-immigrant visa. It is not a green card. It is not an immigrant visa. A green card or an immigrant visa are for those who want to permanently stay in the U.S. An E-1 visa, in contrast, is a temporary visa, non-immigrant visa, that requires that you not intend to remain permanently in the United States. Now, that being said, as long as you remain eligible for the E-1, meaning that the business continues to be eligible through its trade and you continue to be eligible through your nationality, for example, then you can renew the E-1 visa indefinitely. There's not a limit on the number of years you can have E-1 status or an E-1 visa as long as you remain eligible. But what is important is that you cannot use your E-1 visa to enter the U.S. and then pursue a green card. There are certain exceptions to this. This is a complicated area of law, so if this does apply to you, we do recommend that you schedule a consultation. So let's talk a little more about what is trade. So I said before that there needs to be trade. So trade is defined as the movement, the exchange of goods or services internationally. So goods could be, for example, selling fabrics. Services can be providing consulting services, tax services, marketing services, etc. What's really key to understand, though, again, is that the exchange needs to be between the treaty country and the United States. So if we're talking about services, these need to be services that are provided from the treaty country to U.S. clients, or vice versa, from U.S. employees to the treaty country. How do you prove trade? So you have a nice list on your screen of very common examples of how you prove trade. So these can be invoices proving that goods or services are being purchased, say in the United States, from the company in the treaty country. Bills of lading, showing that you're actually engaging in the movement of goods. This can include, similarly, Department of Homeland Security, excuse me, customs documents. So if, for example, you are moving coffee beans, say from a foreign country, a treaty country, to the U.S., you would have proof that you are filing the necessary documents with Department of Homeland Security Customs, declaring what you're moving, the payments, payment for those goods. You would also have invoices showing that the goods were purchased. So really, in your specific circumstances, you would think about what documentation, what paper trail is created as we engage in this international trade. And in general, that is going to be the documentation that the government is going to want to see. They're not going to take anything based on your word alone. So it's not sufficient to just include a declaration that says, I have a business abroad in a treaty country that is engaging in trade with the U.S. They actually want to see documentation. They want you to prove that. So these are examples of what you can include. Also, the company's tax returns. So that is very helpful proof to show this is an active company that is actually engaging in the sale, the exchange of goods or services. And you can also include some documentation that's not what we would call primary documentation. So for example, you see a trade spreadsheet for the last couple of years. So a trade spreadsheet would be kind of a summary that you can create through Excel, say, that lists out all of the exchanges, say, purchases, sales, to which country these exchanges are going to, and the amounts, so that you can prove that there is regular trade going on. Excuse me. So I mentioned before that what the law says is that there needs to be substantial trade. So that is good, but it's also bad. It is good in that it gives, because excuse me, let me start by saying why it's bad. It's bad because it doesn't give you a set dollar amount. So there is a certain amount of ambiguity. So you cannot have absolute certainty that even if you're engaging in $1 million of trade a year, well, I meet the substantial trade. That's not the clarity that the government gives us, unfortunately. But it's good because it means there's not necessarily a minimum. If you can make a compelling argument about how your trade is substantial, then you stand a chance to be approved. So this vagueness can actually work in your favor, especially if you're a small business that engages in frequent transactions, but those transactions are not of a huge value. So let's talk a little bit more about that. Substantial trade is really defined as a continuous flow of trade between the U.S. and the treaty country. So a continuous flow is key. The government is looking at the number of exchanges of trade between the U.S. and the treaty country over a period of time. In general, the government is looking at frequent and regular transactions. Okay, so trade should be, when you're showing the government that you actually are engaging in substantial trade, the trade should be over a minimum of 6 months. So that should be the minimum window you're looking at, you're presenting to the government. And in general, you want to show that trade is exceeding $250,000 a year. Now, this is just a helpful benchmark. If your trade is not meeting that amount, there may be ways for us to craft arguments about how nonetheless you may qualify for an E-1 visa. But in general, it's good to strive for that $250,000 per year mark. Consulates do tend to focus on the volume of trade, meaning the number of clients and the number of transactions, and the monetary value of transactions. Now, single transactions will typically not be enough. What we mean by that is, let's say that your window is 2025, and your company did one transaction in 2025 worth $2 million. That is probably not going to be enough, because that does not establish a continuous flow of trade. Even though the amount is significant, it's a one-time one-time transaction, and that will generally not meet the substantial trade requirement. Can a small business qualify for the E-1 visa? This is what I was mentioning before. The answer is yes. They can a small business can qualify for the E-1 visa if they can show numerous transactions over a period of time, even if those transactions are smaller in value. So what you're seeing here is that while the frequency of trade is important and the value of trade is important, frequency does tend to be more critical than the value of the trade. So it is better to have frequent, regular transactions, even if they're not an enormous value. It's better to have that than a very low frequency transaction, say one transaction, worth a high value. And next, trade must remain substantial even after the E-1 visa is granted. So, a few other trade considerations. So, we're going to go into a little more depth on some of the things we've already mentioned before. In general, trade should already exist at the time that you're applying for the E-1 visa. So you do want, again, you want to be able to look at a window of time in the past that shows the frequency, the volume, the value of trade that the business is doing. If you have not yet met that requirement, then the E-1 visa is not the best option for you. The B-1 may be a good option for you. A B-1 visa is a business visitor visa, and it is explicitly meant for people to come to the U.S. essentially to seek business opportunities, to meet with partners, to not engage in active employment or active generation of income, but to take steps to build a business that may be the basis for an E-1 visa in the future, or if not necessarily to build a business in the U.S., then to build exchange between the U.S. and the treaty country in preparation for an E-1 visa. And again, it's really critical to understand that the B-1 visa does not allow labor. It does not allow active work. It really is things to set up a business. So, for example, to sign a lease, to sign a contract, to meet with business associates, etc. So one last thing I want to talk about before passing it off to Ian is this idea of international trade. Because I said before, I've been emphasizing trade between the treaty country and the United States. It is fine if the business engages in international trade between the treaty country and another country as well. But what is critical is that at least 50% of the international trade of the company needs to be between the treaty country and the United States. So in this example, this helps to walk through this. So let's say there is a company in Spain. It manufactures glass and it exports it to other countries, and it does trade within Spain. So that would be domestic trade, not international trade with Spain. So the breakdown of sales is as follows. So domestic sales of the Spanish company, so sales within Spain, are $100,000. Sales to the United States, so that is international trade, total $500,000. And sales to China, which is also international trade, totals $500,000. So the total international trade is $1 million, $500,000 to the U.S., $500,000 to China. I'm going to call it trade. It's sales within Spain. Don't count, because that is not international trade. So international trade totals $1 million. Of that million, trade with the U.S. is $500,000, exactly 50% of the international trade. Therefore, this business does meet this requirement, because at least 50% of the trade, of the international trade, is with the United States. So hopefully that helps to make clear that international trade requirement between the treaty country and the United States. So with that, I will go ahead and pass it to Ian to talk about a few more aspects of the E-1 visa.
Great, thank you very much, Dustin. I feel with E-1 visas that they always get a bad rap because I think everyone often talks about E-2s and E-1s are the delinquent brother or sister of an E-2 and they often don't get a lot of traction or mileage. But certainly when we come across situations where someone is eligible for an E-1 and eligible for an E-2 at the same time, we often will encourage them to get the E-1 because there are a lot of advantages where you don't have to hire employees, you don't have to get it's not really necessary to get a lease, you don't even have to have a business entity in the U.S. And certainly, even a business plan isn't something that, if the trade has existed for a long time, that you could go without. Whereas all of those things, including investment, the E-2 requires that you actually invest in the United States. But all of those things don't exist with an E-1. So sometimes when someone is eligible for both, and we do have situations like that, we will utilize an E-1. So the question is really, where should you apply? Now, you can apply at a consulate if you're abroad. You will have to apply at a consulate. But if you're in the United States on some other visa stat, in some other visa status, B1, B2, or some other visa status, TN, H1B, et cetera, and you decide that you want to apply for this, you could apply through USCIS. But typically, we see that applying at a consulate is a better option for people because the E1 visa can be issued from anywhere between 3 months and 5 years, but the majority of the countries, of those 80 countries that Dustin talked about, because that's going to determine how many years the visa is issued for. The majority do have a very long dates, like they're granted for the full 5 years. So that gives you, and the visa is an entry document, so it gives you the ability to come and go for a 5 year period. Whereas if you do a USCIS filing, then you are going to change your status for a couple of years and you can continue to do that in the United States, but you are landlocked and you're not allowed to travel internationally. Or if you do travel internationally, you'll be required to get the visa the first time that you leave. Now, the one benefit of a consulate, or sort of USCIS rather, is that sometimes they can be a little bit more objective because a consulate, it's going to really depend on the officer that you get, and the officer may give you a reason for not approving the case, or not give a reason at all, just not approve it. Whereas when you do file through USCIS, they do have to provide legal arguments or reasons why it is that they are not going to grant the benefit. Because when you're in the United States, you are afforded some type of due process, but that doesn't exist at a consulate. So. So as I mentioned, one of the benefits of an E-1 is that you don't really need a business plan. Sometimes we will include a business plan. As Dustin said, the trade should really exist for a while. Ideally a couple of years, but sometimes the trade may exist for a shorter period of time, like 6 months or something. And in those instances, we might put a business plan into the file to explain that the E-1 business is going to he's going to have trade over an extended period of time. And keep in mind that I said that the E-1 doesn't require an entity in the United States. So often the E-1 entity that we're talking about is the actual entity abroad. And that's the entity that you're going to be looking at to make all of these determinations as to whether or not the trade is substantial and whether 50% of the trade, whether the 50% trade requirement has been met. So as I mentioned, also the E-1, a benefit of it is that you're not required to hire any employees. Employees are always going to be beneficial. If you do have employees, then you can point to that in an E-1 file, but it's not going to be necessary. And E-1, an E-2 doesn't require a lease either, but sometimes a lease can be much more beneficial for an E-2. Whereas for an E-1, I don't think it's really even something that if someone had that we would even include in the filing because it's just not relevant at all, and there's no requirement for any type of investment. Some of these we covered already. Let me see, is there anything that we didn't cover here? No, I think all of these we've covered. So what ends up happening often is that the individual is working for the entity abroad, and then the E-1 gives them the ability to come to the United States to facilitate trade. And that can be done in a number of different ways. It can be done where they still have a very strong tie to the entity abroad. It could be done where the entity abroad sets up an entity in the United States and they utilize that entity to pay the person. It could be that if the person isn't in the United States, is often that they continue to be paid by the entity abroad, and you do have to kind of work out all of the tax implications associated with that. But really, when the E-1 trader is coming to the United States, they're coming to the United States to facilitate trade. So the relationship is a bit different from the E-2 relationship, where when someone is an E-2 investor, they're coming to the United States to develop and direct the operation. And that invariably would mean that they're either an employee of or a director of the business taking remuneration through distributions and things like that. So. You know, E-1 visas, and as with E-2 visas, they have very high approval rates. The government posted approval rates are over, oh, last year they were over, or the year before that. I don't know if they published last year's 2025 yet, but they were over 90%. Our approval rate for e-visas in general is 98, 99%. Past results don't predict future outcome, but that is what our approval rates are for the two types of visas. But sometimes, something might get denied, and why is that? So one is that they, maybe just don't meet the requirements, that the trade isn't actually substantial, that it's too low. And we do see this sometimes in consultations where, because the trade can be anything, right? The trade can be service, it can be a good, but just that the trade amounts are really low. Someone who has a business and they're shipping $100,000 worth of goods or services to the United States, and that typically would be too low. Usually, we see trade amounts of 250,000 or over to meet the requirement, and that would be the portion of the trade that related to trade with the U.S. So that would mean that the overall trade of the organization was higher if they traded with other countries as well. The other issue could be that there are not a lot of clients, and so someone's doing trade, but there's only one client. Like it improves your case if the trade is with a number of different organizations or clients. The other kind of thing that happens sometimes is that someone wants an E-1 and they have the entity abroad, but they are the only one that is providing the service. Let's say, so, the trade is a service. They're the only ones providing the service in the foreign country, and they want to come to the United States. Well, that would kill an E-1 right there. It would be okay for E-2, but that would kill an E-1 right there, because the person was no longer going to be, if the person was no longer going to be in their home country, they couldn't be providing trade on an ongoing basis. If they were the ones who came to the United States and they still had employees in their home country that were still providing the service, then certainly that could work. But right away, sometimes from the onset, we have to tell clients that E-1 may not work. But sometimes if they want to, keep really minimal staff in their home country and then come to the US, that may not work either, because the government may not feel that the trade that's actually going to be done over a period of time is going to be significant. The third bullet point is similar to the second. Then, just again, like just not meeting the requirement, right? So you do have to kind of start out, and it can be complicated because some of the sales can be internal to the country, and that's excluded from the trade amount. But you really do have to get an inventory of all the trade. So who is the company trading with? Which countries is the company trading with? Get a complete inventory, and that often would start with the tax returns. So, okay, let's say there's $1 million in the tax return, 100,000 relates to sales within the country, 900,000 relates to other countries. Then you have to take that 900,000 and use that as a control total, and then see if 50%, so if it's 450,000 of that trade with the US. So that is a process that, if you don't meet the 50%, then you may not be eligible. And then, as Dustin said, the best way to put these cases forward is that the trade has existed for a long time. So, and usually a couple of years is ideal. So The renewal of a E1 is very much based on just reaffirming that what existed at the time of the application currently exists. Unlike an E2, where the renewal is based on looking at how many employees have been hired. The renewal of an E1 is really just going to be based on does the person continue to meet the E1 requirements? That is, are they trading? Is the trade substantial? Is it over 50% of the overall trade, et cetera? So that's really what the focus is going to be on when you are renewing. So.
Perfect. I think that wraps up
Perfect.
our presentation. We have a few minutes if there are some last minute questions anyone wants to send in, but so far I think we haven't received any yet. So I'll go ahead and thank you, Ian, for sharing your
Thank you.
expertise, and I thank you to our audience for joining us today. Do keep an eye out for our email that we'll send to you with a link where you can schedule a consultation or join us for our future webinars. In the meantime, stay well,
Perfect.
everyone.
Great. Thank you, Dustin.
Thank you.
Thank you, everyone. Bye.